So you have a plan to exit, but do you have an exit plan? If you're leaving your job to go to a competitor without a plan, then much like the old adage, you're planning to fail, and failing can be disastrous. So in this training, I'll help you create a proper exit plan. To do that, I'll explain the common mistakes that people make when leaving their job, and I'll explain how to avoid those mistakes. Let me set the stage. Did you know that more than half of people surveyed admit to taking their company's confidential information when they leave for a new job? It's true, and that's just the people who admit it. That costs companies hundreds of billions of dollars a year, which harms not just the companies, but the employees who remain there too. And the person that took the information may not only have to pay for the harm that they caused, lose their new job, and wind up having their career derailed, but in some instances they can also be held criminally responsible. Fortunately, a great deal of problems like these can be avoided with some education. So in today's training, I'll be providing that education, as well as some additional guidance about how to be a good leaver. So welcome to the 10-minute Trade Secret Training Series, The Exit Plan, Being a Good Leaver. My name is Russell Beck. I'm a trade secret, non-compete, and employee mobility lawyer at the law firm Beck, Riden. But although I am a lawyer, please understand that I am not your lawyer, and this is not legal advice. If you feel you need legal advice, or if any of the issues that I discussed today raise any concerns for you, you should speak with a lawyer to evaluate your particular circumstances and obtain proper legal guidance. Okay, let's get started. Unless you have an employment agreement for a specified duration or you have specific resignation notice requirements, you're generally allowed to leave your job anytime you wish. But how you leave and what you do beforehand can mean the difference between making a smooth exit and ending up in court. Understand that everything changes when you decide to leave. What was once acceptable, normal business activity will now be viewed with skepticism and suspicion. So as we work our way through, remember that the guiding principle is to avoid doing anything that harms your employer. Maintaining proper business ethics should be your lodestar or your guide. If you feel that something is wrong, it probably is, and you probably shouldn't do it. So we're going to talk about 3 common mistakes that people make when leaving or preparing to leave a job. First, they take or retain company information or materials, sometimes intentionally, but other times inadvertently. Second, they try to convince customers or colleagues to leave with them. And third, they lie about or try to conceal their new job from their current employer. Let's turn to the first mistake, taking or retaining company information or materials from a soon-to-be former employer. Remember the old adage, you can't take it with you? Well, it applies here too. The rules are simple. Take nothing, retain nothing, and return everything. Let's explore that a little more. People often think that as long as they don't take their employer's top secret information, what they think of as trade secrets, then it's okay to take other information and materials. They're wrong. While it is true that you can't take trade secrets are an extremely broad category of information not limited to a company's crown jewels. Really, any information that's confidential and gives the company a competitive or economic advantage, no matter how seemingly insignificant, can be a trade secret. But don't get hung up on the term trade secret. It's a term of art for lawyers. The reality is that employers are entitled to protect all sorts of confidential or proprietary information spanning across all business units, from research and development to sales to operations to manufacturing to every other aspect of the business. For more information about what can be protected and some specific examples, click the link in the box on the top right or click the link in the description below. Now, not all confidential and proprietary business information is protectable. For example, an employer can't prevent you from using your general skills and knowledge. But the line between confidential information and general skill and knowledge is rarely as clear as it may seem. Even lawyers and judges can have a difficult time distinguishing between what an employer can protect and what it can't. So you should always err on the side of caution and assume that the information is protectable until you're certain that your former employer won't contend otherwise, whether you agree with them or not. Let's turn to a few common areas of confusion. First, people sometimes think that if materials are not labeled confidential, that they're theirs for the taking. They're not. The law does not require any type of marking or other indication. Another common area of confusion is that people often think that PowerPoint presentations and Word and Excel files are okay to take as templates. They're wrong. Templates often come with proprietary information or are proprietary in and of themselves. And it doesn't matter why you want them or why you want any other company materials. Taking something as a template or to improve on it later or just to use it for personal reference does not make taking it any less illegal. It also doesn't matter that you created or contributed to the information or materials. That also doesn't make them yours to take. Another common area of confusion is that people sometimes think that they can take information or materials because it's on their personal computer or other device. But where the information or materials are stored rarely matters. If it's the company's information or materials, the fact that you have a copy doesn't change that. And a related area of confusion is that people often think that it's okay to take customer contact information, maybe because it's on their personal cell phone or because they've become friends with the customer. In most instances, it's not okay. And just to be clear, trying to take the same information by memorizing it is no less unlawful. Even rushing to try to connect with customers on social media as you're getting ready to leave may be unlawful. This is a very technical area of the law that varies by state, by industry, and by particular relationships. So before taking or using any customer information, it's generally best to obtain permission from your employer or to discuss the issue with a lawyer. So what does all this mean for you? It means you should work as you would as if you had no intention of leaving. Of course, like most absolutes, there are exceptions. In particular, once you know that you're leaving, you should be vigilant to avoid putting yourself in a position to learn new information or to become refreshed about information that you learned previously and may have forgotten. So let's start with the things to avoid, the don'ts. Don't attend any meetings that you don't have to if attending the meeting will expose you to confidential information that you don't already know. Don't access information that you don't need to access in order to perform your duties, and don't access or even try to access what you don't have a right to, whether it's particular information or areas on the network that you don't have a right to access. Don't email any company information or materials to yourself, not even from your personal account to another personal account. It doesn't matter that it might be the way that you normally work or that it's the most efficient way to get yourself the information for proper work purposes. At this point, you need to avoid engaging in not just any improper conduct, but also any conduct that can appear to be improper or raise suspicions. And emailing company information to a personal email account is a method that is often used to unlawfully take company information, so avoid it. Don't stick any thumb drives in your computer. Again, it doesn't matter if you've done it 100 times before and that's how you transfer files. It's another very common method that people use to take company information, so avoid it too. Don't back up your work computer or company information to any personal backup or syncing devices or services. That means that you need to stop all automatic personal backups and syncing, and that includes Time Machine, Backblaze, iCloud, Dropbox, Microsoft OneDrive, Commvault, CrashPlan, Google Drive, all of them. Now, if the backups are syncing or to the company's account, the opposite is true. You should continue to allow those backups. Old school methods of taking information don't work either. Don't stick documents in your briefcase, your backpack, or your gym bag. Don't take them in a box with your personal effects. And don't copy information by hand or study it and write it down when you get home. Now, this doesn't mean that other methods of taking information or property are acceptable. The methods that I just described are just examples of some common practices. But there are other practices that are just as improper. For example, don't print out hard copies of documents you shouldn't be taking. And that obviously means that you also shouldn't take pictures of printouts of documents or message them through WhatsApp to encrypt them. That goes the same for pictures of products in development or information on your computer screen. And likewise, don't take pictures of information on a whiteboard, even if you just want it to help you remember what you saw. And don't ask colleagues to collect information for you. Doing something indirectly doesn't relieve you of liability. It'll only also create a problem for your colleague. So how do you leave the company's information with the company but take your personal information with you? Well, the best way to handle that is generally to work cooperatively with your employer to disentangle your information and property from theirs and theirs from yours. Now let me head off one very common mistake. You may sometimes read articles in the news that advise you to just take your personal information and then wipe your computer clean. Those articles are about protecting your personal information. They don't focus on the problems that you create when you erase company information, or the inferences that your employer or a court may draw from the fact that you wiped the company's computer. Wiping a computer or other device is a huge red flag. Don't do it. Instead, the starting point is to determine if you already have information or property of the employer in your possession, and if you do, why. Do you have any materials that you printed or that someone else provided to you? Do you have electronic copies of documents? You might find those on backup drives, thumb drives, or tablets, or maybe in your personal email or online storage accounts. Do you have any company information in your pictures on your smartphone or on other personal devices? Once you've determined whether you have any of the company's information or other property, if you do, you'll need a protocol for ensuring that you don't retain any when you leave. One of the key factors in establishing an appropriate protocol turns on how you obtain the information. If you came into possession of the information properly, meaning in the ordinary course of performing your job and not in anticipation of leaving, then there are likely no special considerations. Typically, the key will be common sense and transparency. In most instances, you'll want to let the company know that you have their information and ask how they'd like it handled. And you may also want to make a contemporaneous record of what you had and what you returned. If you do, it typically should be descriptive enough without including any confidential information so that anyone reviewing it would know what was returned. But what do you do if you've already taken company information or materials in anticipation of leaving? The answer is informed by a highly factual inquiry that's outside the scope of this training, but it will depend on a host of facts and circumstances, including what the information is, what format it exists in, where else it exists, why you have it, when you took it, how you took it, whether you reviewed it, and if so, when and why, where you are in your job search, and your relationship with your employer, just to name a few. This is typically something that you'll want to discuss with a lawyer. What if your personal materials are on your employer's computer and you want to take them with you? Most often that's not a problem, but generally it's best to talk with your employer about a method for taking them. Part of the reason that you want to be transparent is that however you would take the information, for example, downloading it onto a thumb drive or copying it to an online file storage account, is going to be the same way that people take company information unlawfully. So it can look like you're taking company information or materials instead of your own. And finally, what if you want to take some company information or materials with you? Ask for permission. It's almost never okay to just take company property, even if you think the company will be okay with it. This really is not an instance in which asking for forgiveness later is better than asking for permission. Quite the opposite. Taking company materials or information without permission is like taking any other property without permission. It's illegal. And if the company does let you take anything, you may want to consider confirming that permission in writing. Now let's turn to the second mistake, trying to take customers or colleagues. The rules are a bit more nuanced and vary by state and circumstances, but they come from two general sources. The first is called the duty of loyalty, and it means that employees are not permitted to do things that harm their employer. The second are contractual obligations, contained most typically in 2 or potentially 3 types of agreements. First are nonsolicitation agreements, which prohibit certain customer interactions. Second are no-recruit agreements, sometimes also called non-solicitation agreements, and those prohibit certain interactions with colleagues. And potentially third are non-disclosure agreements, at least to the extent you have information that would aid in the solicitation. These contractual obligations can vary wildly, so you should obtain and review all documents containing any contractual obligations that you owe to your employer. Those are often found in an offer letter you signed when you started or when you received a promotion. They also may be found in an employment contract or a restrictive covenant agreement or an information protection agreement. They're also commonly found in long-term cash award programs, option agreements, and stock awards. But wherever they may be at your company, you should make sure that you've obtained and reviewed all of them. This is an instance where reviewing your obligations with a lawyer can often save you from making costly mistakes. But in the meantime, it's important to know that until you've left your job, they largely overlap with the duty of loyalty. And because the goal of this training is for you to understand how to avoid the common mistakes, we're going to focus on the general obligations and how to think about them. So let's turn to the solicitation of customers. And when we talk about customers, the rules typically apply equally to referral sources, vendors, and suppliers. The starting point here is that while you're working for your employer, you simply cannot solicit its customers or prospective customers to leave with you. And that also means that you can't try to delay a deal so that you can bring it with you to a new employer or fail to disclose customer feedback that can help your current employer. And while you might think that you can just take your chances, you should know that it's quite common for customers, even your longtime customers who seem friendly, to report violations to former employers, or for former employers to find out about violations from an errant email they receive from a customer. Just think about how your email auto-populates contacts when you begin to type their names. That makes for lots of potential problems down the road. After you leave, the rules change. So by that point, you want to make sure that you have clear guidance on what is and what is not permitted by any contract or other restriction you may have. Turning then to the solicitation of colleagues, the same rules apply. While you're still working for the company, you should not solicit your colleagues to leave with you. It's just that simple unless you've spoken to a lawyer about the nuances of your particular circumstances and you've been advised that there's some reason that you can. As a general matter, the best way to avoid violating these obligations is to have no involvement whatsoever in any decision a colleague may make to leave their job. Don't discuss your plans with them, don't encourage them to leave their job, don't suggest they join you, or even tell them how much you'd like to work with them again. And don't help them apply for a job or recommend them to your future employer or even suggest them as a potential candidate. While in many instances it's actually okay to do some or all of these things or to provide general career guidance to colleagues, doing so may in other circumstances constitute a breach of your duty of loyalty or your no-recruit obligations. And while it may seem harmless at the time and just a private conversation among friends, employers usually do find out, and the liability for a violation can be quite significant. A common area of confusion is that people often think it's okay to communicate with customers or colleagues about these issues through personal email or text. It's not. The medium through which the communication occurs is irrelevant. So before engaging in any communication, whatever the method, make sure it's consistent with your obligations to your employer. Now let's turn to the third mistake, lying about or trying to conceal your plans from your current employer. Employers often will ask what your plans are. There are 3 ways you can answer that. 1, truthfully. 2, with a lie or misdirection like, I'm going to spend some time traveling so I can rethink my career, when in fact you're planning to start a new job. And 3, refusing to answer. Only one of those won't land you in trouble or wind up in the first paragraph of a court filing, and that's telling the truth. The others show a consciousness of guilt, or at least that's the inference that your former employer and the courts will likely draw. So if your employer asks what your plans are, most times you're best off answering honestly. And even if your employer doesn't ask, there are times when you may want to or be required to volunteer where you're going. This can be required by contractual provisions or just by circumstances. So before resigning, it's best to understand under what circumstances you'll need to volunteer your plans. The issues relating to these obligations can be very fact-specific and are best discussed with a lawyer as early as possible. I'll end with a few takeaways. It's generally best to leave on good terms if that's at all possible, and if it's not, it's almost always best to avoid creating any unnecessary acrimony. With that in mind, don't take or retain any information of your employer, and if you do have any information, make sure you have a plan for how you're going to handle it. Don't try to take customers, clients, or colleagues, and understand what your obligations will be after you leave. Don't lie about your plans, and make sure you know under what circumstances you should or will need to volunteer your plans. And finally, don't burn any bridges that you don't need to, including by bad-mouthing your employer. The key is to stop and affirmatively think about the issues and this guidance before you do anything that may create more serious problems. Common sense and integrity will go a long way. If something just doesn't feel right, it probably isn't, and you probably shouldn't do it. And remember, whenever you have a question, ask it. Thank you for your time and attention, and good luck being a good leaver.